everyone. My name is Silas Allard. I'm the editor-in-chief of the Emory International Law Review, and I'd like to thank you all for coming to the final installment of our symposium, Who Should Prosecute? The Challenge of International Terrorism, the Response of International Law. We've had three events so far, which have been really wonderful. We've got a comparative perspective in our first event between Russian and German perspectives on the use of international law. In our second event, Judge Evan Wallach of the International Court of Trade gave us a historical perspective on non-state actors and the law of war prior to the Geneva Conventions. And then in our third event, our keynote address, Professor Amos Giora gave us quite a tour de force through various ways of dealing with terrorists, and eventually came down on this, his idea of national security courts. We'll get something of a revisit of some of those models today from our panel, and I'm excited to see how the contrasts and comparisons are drawn. And today, to elaborate on that, we have with us three wonderful panelists who are going to discuss sort of the opportunities and the challenges that the international tribunal model may offer for the problem of terrorism. And when they are finished, Professor van der Vyver is going to offer us a response. The style is going to be a little informal, if you will. Each of our panelists are going to present about 10 minutes of their perspective on the international tribunal system and its application to the issue of terrorism. And then they're just going to have a discussion among themselves, bringing their various expertise to the table to talk about these issues. Professor van der Vyver will offer us a response, and then we will have probably 30 or 40 minutes of open discussion with our panelists and the audience and Professor van der Vyver. But before we go on, allow me to introduce our august panelists. On the other side of Professor van der Vyver is Michael J. Kelly. He's the Professor of Law and Dean for International Programs at Creighton University School of Law. He's also the President of the U.S. National Chapter of, and please forgive my French pronunciation, I don't know any of it, l'Association Internationale du Droit Pénal, a Paris-based society of international criminal law scholars, judges, and attorneys, founded in 1924, that also enjoys consultative status with the United Nations. Finally, he has served as a chair in 2009 of the National Security Law Section of the Association of American Law Schools. To his left is Ms. Laura Olson, who's currently senior counsel at the Constitution Project and president of Blackletter Consulting, LLC. From 1997 to 2008, Ms. Olson worked for the International Committee of the Red Cross, and during which time she was the legal advisor to the ICRC's regional delegation in Washington, which included providing legal support for the ICRC visits to the detention facility at Guantanamo Bay. And to her left is Ms. Sandy Hodgkinson. She is currently Chief of Staff for the Deputy Secretary of Defense, and she's former Deputy Assistant Secretary of Defense for detainee issues, and also former Deputy Ambassador for war crimes issues. And then, as I've said before, Professor van der Vyver, who is currently the I.T. Cohen Professor of International Law and Human Rights at Emory Law, and a former Professor of Law at the University of Witwatersrand in Johannesburg, South Africa. He's an expert on international human rights law, involved with the promotion of human rights in South Africa, and served as a fellow in the Human Rights Program of the Carter Center from 1995 to 1998. He also has a brand new book, fresh off the presses, Implementation of International Law in the United States from the Peter Long Publishing Group, which came out, I think, within the past week. So please welcome all of our guests, and I think that Ms. Olson is going to lead us off.
Yes.
All right, thank you very much.
Thank you very much for the invitation to be here and for the warm welcome. I will start by providing more of an introduction, a little bit of a comparison between the using domestic for or having domestic trials for terrorism crimes versus the international fora. This will allow me to go into, which I'm not sure my colleagues will go into, which is a bit the interstate cooperation and what needs to happen, particularly if there's domestic trials. And then I'm going to address the issue of the definition, particularly how it relates to the law of armed conflict or international humanitarian law. When I used to work at the International Committee of the Red Cross, whenever you start talking about international humanitarian law or law of armed conflict, I'll probably use them interchangeably. See, it shows I've changed from my ICRC days, because then we'd only say international humanitarian law. We'd never say law of armed conflict, or IHL for short. But we describe maybe the rules in a setting like this on a panel, and eventually after you started talking about the rules, everyone got to the point of the what about enforcing it? What about this issue of impunity with these war crimes? How do you handle that? And so inevitably we started discussing ad hoc tribunals or the International Criminal Court. And one thing I would always remind people is, actually, at least for war crimes, under law of war, you shouldn't need an international court, because there's already an obligation by all states in the world to prosecute and or extradite suspects for such crimes. But that being said, that doesn't mean these tribunals don't necessarily have a role. It's just we have to keep in mind that the domestic, or my position would be the importance that national courts still need to play, and that we can't, for example, evaluate the ICC's prospects for prosecuting terrorism criminals without, well, in fact, we should rather compare the ICC's capabilities or any other international tribunal with the domestic system. And that certainly the international tribunals can't be a cure-all without addressing state capacity. So with regard to domestic trials or domestic fora, I think it's important to keep in mind that acts of terrorism, when they have been prosecuted in the past, that they are traditionally a crime prosecuted domestically and tried by regular domestic courts. Often the proceedings in a domestic court of the country where the acts occurred will more likely have access to the evidence that's needed, the available witnesses, surviving victims or families. But in contrast, a country whose nationals maybe were also victims of the act that occurred, the Terrorism Act, may believe that a second country's legal system is not up to the job and won't be legitimately provide justice. So those are some of the challenges. So here's where I'm going to deviate a moment to talk about some specific challenges of interstate cooperation in penal matters, which is particularly relevant if we're talking about international terrorism acts, because the acts probably didn't necessarily occur in the state that's trying the perpetrator. Of course, this is not a challenge that's unique to terrorism. It's war crimes, crimes against humanity, many other crimes. And interstate cooperation, then, what do I mean by interstate cooperation in criminal matters? It's the deliberate provision of support in criminal proceedings in a different forum. So for crimes under international law, interstate cooperation is actually the linchpin if we want effective enforcement and we want to end impunity for such crimes. So when you deal with interstate cooperation, there's a variety of things that have to be addressed. One is the issue of extradition. I'm only going to list them here because there's lots of things we could talk about, but I won't do that now. But extradition, mutual legal assistance, so for example, providing evidence, transfer of criminal proceedings from one state to another, enforcement of the effects of another state's penal judgments, and perhaps transferring someone who's already been convicted for sentencing, though, and the carrying out of the sentencing in another country. On all those issues, or those particular matters, there are issues of state sovereignty and individual rights that come into play and pose their own challenges when the states are cooperating. In order to, when states want to have interstate cooperation, they usually establish bilateral treaties on how they're going to cooperate under specific acts. One of the things that we've seen in some substantive treaties now that deal with specific crimes, like the terrorism crimes, is they actually create these, what I call these mini conventions, mini mutual legal assistance conventions within the convention itself. Well, they'll list ways that states are supposed to cooperate. For example, on purposes for which assistance may be requested, so when one state can ask another what to do, the grounds for refusal to provide a person and or the evidence. Maybe the convention itself and some of these terrorism conventions will stipulate the creation of a central authority in one particular state to handle such requests, to facilitate the requests when they occur, and the procedures for making such a request. Such detail in the Terrorism Convention on Financing Terrorism, for example, or terrorism bombings, helps state ensure that they can then prosecute the crime domestically. Because, as you know, of the treaties that we have out there dealing with the specific terrorism crimes, it all is still expecting the states to prosecute the crimes domestically. So by having these mini mutual legal assistance treaties within the substantive criminal treaty itself, it helps facilitate the process. That said, those treaties usually, in a sense, you can say, have a savings clause, that if there is a specific mutual legal assistance treaty between two of the state parties to the criminal convention, that mutual legal assistance treaty, which is probably even more detailed than the mini convention within the substantive treaty, would take precedent. So that's my deviation a bit on mutual legal assistance, which I think in the end we always have to come back to, because even if we think and we find that international fora have a role to play in the crime of terrorism, if we really want to end impunity on any crimes, whether you're labeling them terrorism or war crimes, which I would consider certain acts of terrorism, we still need national courts to prosecute, and this is all part of the process for that to happen. So now looking at international fora, like the ad hoc tribunals or the ICC. Just maybe quickly, as I know Michael and Sandy will get into more detail on this, but what are some pros? Well, the pros of an ad hoc tribunal is that the UN can compel states to cooperate. You don't have to worry about a mutual legal assistance treaty. With peremptory powers of the Security Council, you would not have to rely on any of those complicated extradition treaties or anything else to obtain evidence and suspects. You would have a single set of procedural and substantive laws that's supposed to apply to all parties for that particular treaty or that particular tribunal. And hopefully, because you have this uniform code, one could say, you have prosecutions that create more certainty and maybe would be perceived as more fair. Some of the cons is that most of these ad hocs were created obviously pursuant to Chapter 7 powers of the Security Council. So you'd have to, in theory, if there was going to be another one similarly created, that would have to be a threat to international peace and security. Obviously, terrorism threats have risen to that level, and I believe it was Resolution 1373 after 9/11 that is what the Security Council said the attacks were of 9/11, but that's something to keep in mind. Particularly if we get into now the definition of terrorism, and it's not so easily defined, what kind of acts would always meet that threshold that would get the Security Council to act in that way. Another difficulty with the tribunal remains that the tribunal is going to have to rely on the support of the Security Council for the establishment and enforcement of its jurisdiction, and obviously we know the Security Council can be politicized, so that could be potentially one could say a threat for the ad hoc tribunal, or at least a threat in fulfilling its mandate, although it hasn't necessarily played out in past ad hocs, although Sandy might tell me otherwise, I don't know. There also might be delays in establishing an ad hoc tribunal if the Security Council has to set it up, and when there's delays, you may lose evidence and the loss of witnesses. And then the final concern is that because there is now the ICC, Security Council may hesitate on wanting, and states may not be really willing to set up any additional ad hoc tribunals. And that was actually a concern that Ambassador Rapp, the current ambassador at large for war crimes, mentioned at the American Society of International Law's annual meeting, that we are looking a bit to the ICC because the current ad hoc tribunals are generally winding down, and there isn't necessarily so much political will now that the ICC is up and running, or potentially there wouldn't be, to have any more ad hoc tribunals. With regard to the ICC, I'll come back to my theme that I started on, is while we do have the ICC, it should be recalled that the Rome Statute envisaged that the ICC, in a sense, should be a court of last resort because the primary jurisdiction still rested with states. So we have to determine what is the solution we want the international tribunals to solve in dealing with terrorism or any other crime, because we can never get away with dealing with the challenges of prosecuting domestically, and that's maybe what we should focus on. So there's the whole issue of complementarity, so that we do come back to domestic trials in the end. It must remain with the states, given if there are a lot of crimes. Clearly, even if the ICC is the best court capable, it can't handle all the cases, even setting aside complementarity. So we need to continually improve interstate cooperation. And of course, while there is uniform procedures and states are obliged to cooperate with the ICC if they're a party to the ICC, there are states, of course, that are not party to the ICC. So while there may be cooperation that's mandatory on getting evidence and witnesses for trials, of course those obligations only extend to the state parties. That's not to say states that aren't party can't cooperate, but they're not necessarily obliged to do so. That said, of course, the ICC is very much dependent, not having its own police force, on states doing the enforcement, getting the witnesses, and we know there's quite a few outstanding warrants. And then, of course, we get to the big but. The big but with the ICC is, of course, it doesn't have jurisdiction over the crime of terrorism. And there's a lot of concern over the crime, given that it's hard to define. In fact, the United States and others in Rome in 1998, as many of you know, were opposed to having the crime in there. One, because it wasn't well defined. There's concerns of politicization. Maybe some acts of terrorism aren't sufficient to warrant being tried at an international tribunal, depending on how terrorism is defined, of course. And some would generally consider that prosecuting, again, at the domestic level would be more efficient. I think a lot of those concerns yet still remain. As you know, terrorism, while the Dutch did propose to put terrorism on the agenda for the review conference coming up in Kampala in June, it is not on the agenda. And that said, even when they did propose it to put it on the agenda, it was put on like the crime of aggression, such that let's try to get the statute amended such that terrorism is included, but we'll worry about defining it later. Like aggression was included in the jurisdiction, but it was going to be left to states to define the crime of aggression later. But again, it's not up for discussion, so there isn't currently a chance that the ICC will do that, at least not at this review conference. So I just quickly want to address the issue of the definition and how it relates to the law of armed conflict. There's 13 different treaties that deal with different crimes of terrorism. You have more treaties that are regional. You kind of consider how we have all these different terrorism treaties to be piecemeal approach, dealing with the different concrete crimes like financing or terrorist bombing. But the concern has been there isn't one comprehensive definition of terrorism. So why don't we try to create a comprehensive treaty that deals with that? Well, they've been trying to do that in the UN for quite a few years. Entitled the Comprehensive Convention, right? The real stumbling point they have is not so much the definition per se, but more the exclusionary clauses, meaning what kind of acts it won't include. And it all hinges really around state, what state acts should be considered as terrorism, and also the relationship to the law of armed conflict. And so just to conclude, I'm just going to raise the issues with that definition, and we can go into more detail in the discussion, is this. There are the basic options for the relationship between terrorism and armed conflicts are first either to exclude or to include acts committed in armed conflict in the definition of terrorism. Second, the other issue that's controversial is whether state behavior should be included or excluded from the definition of terrorism. Excuse me. And third, if terrorism should only cover acts prohibited by international humanitarian law. And I would say that however these, and we can go into the, if we want in the discussion, we can look at the draft articles that have been proposed for the Comprehensive Convention to give more concrete, make this more concrete than what I'm saying now. But however these controversies are solved, in my view, the solution should not refer to the legitimacy of the cause for which someone is fighting, but should refer to the methods that are actually being applied. And furthermore, the two sides of an armed conflict should not be treated differently by international anti-terrorism law. So I mean, whether it's a state or a non-state actor, they should be treated the same. Thus, it would, in my view, be preferable not to criminalize in armed conflicts an act as terrorist if that act is not prohibited by the law of armed conflict, or IHL. Because if some of those acts in such cases were criminalized, it could weaken incentives by one party or the other to respect the laws of armed conflict, which try to make armed conflict more humane, right? So we don't want to undermine respect for the law of armed conflict. So, for example, and then I'll conclude with this, if a convention against terrorism applied to irregular armed groups, let's say that it said that almost any explosives that they use, for example, against military forces, which using explosives against military forces in an armed conflict is allowed by the law of war. If that was prohibited in a convention, and you can consider such acts as terrorism, this would weaken the incentive for such groups to distinguish the acts between targets that are civilian and those targets that are military objectives. Right now, the law of war would already prohibit attacking civilians, but it doesn't prohibit attacking a military objective if you're a party to a conflict. But if an international terrorism treaty did that, then it would lower the incentive to respect the laws of war as they currently exist. So that's my main concern with any definition that comes out, and that it would just be important that the definition of terrorism must be very precise in the manner and how it relates to the law of armed conflict. And I've already spoken too long, so sorry about that.
No, you haven't.
Oh, okay.
Well, I want to respond a little bit to your keynote speaker, Amos Giora. He raised four different possible solutions to the problem of trying terrorists. Article 3 courts, military commissions, a national security court, and international treaty-based terror courts. Silas is having us sort of focus today on that fourth one, international treaty-based terror courts. Professor Giora, unpacks some of the problems with that, but an area that he doesn't go into is what I think is a key weakness of going down this road at this point, is the participation, or more properly lack thereof, of the Muslim world and Islamic states in the development of international criminal law and participation in those institutions. Because let's be clear, we're talking about Islamic terrorists here. No one's talking about international tribunals for IRA bombers or Basque separatists. We're talking about Islamic terrorists. And so if you're starting to go down the road of setting up international terror courts, those are going to be your suspects and your defendants. And if the Islamic world is not participating in the process, then very quickly it becomes an us versus them proposition. And that feeds into the rhetoric, frankly, that terrorist leaders use to recruit more terrorists. So this could very well spiral down to actually undermine what we're trying to do. I want to talk about that a little bit in conjunction with the constellation of models and structures that are available with respect to international tribunals. I did a study on this a couple of years ago that appears in volume 14 of the Yearbook of Islamic and Middle Eastern Law, if you'd like the fuller piece. But we go back, to Nuremberg, and that was really the first time that we began in earnest with the trial of, or the internationalization of international criminal law. But it was really in the 1990s moving forward that you had a proliferation of international institutions that gave rise to a variety of structural models available for the prosecution and adjudication of violations of international criminal law, which is genocide, war crimes, and crimes against humanity. It does not include terrorism at this point. Although, if Laura's definition is adopted, then perhaps that could enter the canon, and that we won't even talk about universal jurisdiction at this point. Nevertheless, even though you've got this different typology of models, very few Islamic jurists or Islamic states participate in the institutions that support the development of this jurisprudence. Two ad hoc tribunals created by the Security Council to address the big three: war crimes, crimes against humanity, and genocide in the former Yugoslavia and Rwanda, were designed to be temporary in nature, narrowly prescribed territorial subject matter and temporal jurisdiction. They were and still are staffed by international legal specialists, not drawn from the countries in which the atrocities took place, and they're physically removed from those states as well. The ICTY, located in The Hague, and the ICTR, located in Arusha, Tanzania, both began operations in 1993. Each court's considered successful in that each added vital justice elements to the conflicts they're associated with. They achieved relatively high degree of interaction among the legal academy and continue to produce complex legal opinions that further elucidate difficult elements of international criminal law. Nevertheless, the international community quickly came to recognize that a chief weakness to the ad hoc systems centered on a lack of involvement and investment by the local community. In short, the ad hoc tribunals were over-internationalized. An attempt to remedy this central weakness was the creation of a hybridized model. Following conclusion of the Civil War in Sierra Leone, the UN worked with the local government there to create a tribunal that contained both local and international judges, prosecutors, and staff, and was physically located in the country where the crimes occurred. UN officials sought to create a similar model for Cambodia as the government began to pursue surviving former members of the Khmer Rouge that participated in the 1975 genocide. In addition to the ad hoc and hybrid models, both meant to be temporary in nature, a permanent model has emerged, and we're all aware of that, in the form of the International Criminal Court in 2002. Located in The Hague and staffed with international experts, the theory behind the ICC is that a venue will be available when local courts cannot or will not prosecute atrocities within their jurisdictions. Moreover, it's meant to be shielded from the potential for politicization that has undermined the Cambodian hybrid court, and it's also designed to serve a larger deterrent element to despotic conduct than previous institutions. Perhaps tellingly, all of the ICC's prosecutorial activity to date has concerned situations in Africa. A final model may lie in the Lockerbie trial example, although that's not really an international model properly, but sort of a domestic model that hit the road. This was a special court that resulted from a political settlement between the United States and the United Kingdom and Libya to try two Muslim Libyan intelligence agents for the bombing of Pan Am Flight 103 over Lockerbie, Scotland. The trial was held in The Hague at Camp Zeist, but tried under Scottish law before Scottish judges. Few nationals from Islamic states participate in international tribunals, and the ones who do are from secularized traditions. The ICTY and the ICTR each have one judge from Turkey and Pakistan. You're not going to find judges from Sharia-based states or more conservative Islamic states. You're only going to find them from Islamic states with a healthy rule of law tradition. The hybrid tribunals for Sierra Leone and the Cambodian special courts have none, and the International Criminal Court has none. As far as Muslim participation in the development of the jurisprudence and the crimes, specifically genocide, war crimes, and crimes against humanity, Islamic states have largely signed on to treaties outlawing those crimes individually, yet Islamic states have not participated meaningfully in the institutions that investigate and prosecute them. Nevertheless, Islamic states have had or will have some level of interaction with these crimes in the context of several international and domestic tribunals. With respect to Bosnia-Herzegovina's war crimes chamber in Sarajevo, and that's a domestic court that will take ICTY overload cases eventually, international and Bosnian judges who are Muslim will be mostly trying Serbs. With Kosovo's war crimes chamber, Muslim, Serb, and international judges operating as a triumvirate will try mostly Serbs. The Iraqi High Tribunal, the IHT, is a domestic court in Baghdad. That will be Muslims and is Muslims trying Muslims. East Timor's hybrid tribunal, mostly Catholics trying Catholics. Muslims are being tried in Jakarta by fellow Muslims under the Indonesian system. In the ICC's investigation of genocide in Darfur, this is mostly non-Muslims investigating Muslims. The IHT, the Iraqi High Tribunal, is the only Arab nexus of these five typologies, three of which are domestic courts. One is an analog to a hybrid court, and one is a full-blown international tribunal. All of these tribunals, including the three domestic courts, were designed by Westerners with American and international expertise, not by Islamic legal scholars. All of the tribunals are code-based. All of the tribunals, except the IHT, experience chronic issues with asserting jurisdiction over defendants, collecting evidence, and administrative concerns with respect to staffing and expertise. The U.S.-led occupation of Iraq allowed the Regime Crimes Liaison Office, a division of DOJ that's located in Baghdad, to render much of these support elements to the IHT. But again, that's staffed by non-Muslims. There will also be interaction among Muslims in the world of international criminal law in the context of the trial that will unfold regarding the assassination of former Lebanese Prime Minister Rafik Hariri. The International Criminal Tribunal for the assassination of the former Lebanese Prime Minister was created by the UN Security Council under Chapter 7 on June 10, 2007, without approval from the Lebanese parliament. The two Islamic states on the Security Council that created the tribunal, Qatar and Indonesia, abstained. Syria, Hezbollah, and Lebanon's president opposed the tribunal. The tribunal will exist outside Lebanon in The Hague. It will be staffed by international personnel, including an international prosecutor, assisted by a Lebanese deputy and a blend of international and Lebanese judges. The UN commission conducting the investigation was not led by a Muslim. It was led by a Belgian prosecutor, Serge Brammertz, very effective prosecutor, now the ICTY chief prosecutor. This will be the first international tribunal to depart from focusing on the big three: genocide, war crimes, and crimes against humanity. Instead, it will concentrate on political assassination. And I had the opportunity to ask the president, Nino Casese, a couple of years ago when we were in Germany, about whether or not he would use this as an opportunity to finally define terrorism instead of just looking at political assassination. And in typical Casese fashion, he waved his hand dramatically and said, "Perhaps." So stay tuned. The Hariri Tribunal will deal with defendants that will likely be Syrian and Lebanese Muslims, yet there will be little Islamic influence in the process. Despite a lack of participation on the institutional side of the equation, Islamic states have sometimes meaningfully participated in the development of international criminal law as it is to be applied if they determine that their interests are at stake. For example, many Arab states participated in negotiations leading to the creation of the ICC, including the final negotiations of the Rome Statute during the 96 to 98 period. Most sought to exclude the designation of forced pregnancy as a crime against humanity and restrict the definition of sexual violence to rape only. A non-interference clause was finally inserted to protect national customs with regard to pregnancy. These states also pushed for the crime of aggression to be state-centered only, to allow for the coexistence of criminalized individual aggression and the duty on the individual to jihad. The first meaning is personal struggle, but the secondary meaning is military struggle against Western hegemony, especially in the Arab world. The crime of aggression was left undefined in the Rome Statute. Very few Islamic states signed on to the Rome Statute ultimately. Of the 104 states parties to the Rome Statute, 20 are Organization of Islamic Council members, many of which are not Muslim majority members, and these are African states. 15 of these have predominantly Muslim populations. Jordan is the only Arab state party. None of the Sharia-centered Islamic states are parties to the Rome Statute, and Nigeria, which is only half Sharia, the northern 12 provinces, is the only party to the Rome Statute with a partial Sharia system. Why are Sharia-centered Islamic states less likely to participate in international criminal law than Western states or even secular Islamic states like Turkey? There's a number of factors that may help explain this disconnect. Obviously, social dissonance, incongruency is a theme that ties these elements together, but the first obviously is Islamic law. If the legal system is derived from religious authority rather than secular, participation is less likely. The level and type of Sharia practiced. If only the commercial or non-divergent aspects of Islamic law are in play, participation is more likely. It becomes less likely if the criminal or more divergent aspects are in play. Cultural drawbacks. The shape and extent of tribalism in the society that may disdain outside interference, together with broad-based cultural expectations like speed and trial and sentencing and victim participation, are factors that come into play. Rule of law factors, independent judiciary, non-existent in most Arab states. Crimes in Sharia jurisdictions are not defined, although the sentences are. This can lead to abuse. Fractured nature of Sharia and the various schools of Islamic law. The level of tailoring in tribunal design to accommodate Islamic traditions, and the level of antagonism by and with the West. I'm not sure that the international models available to us are the way to go with respect to Islamic terrorists for all the reasons I've laid out. Until they can be made stakeholders in the process, I'm very much afraid that to push too hard down this road is going to end up in an us versus them scenario, which we already deal with on so many fronts today.
Okay, well, thank you. I have the opportunity to play sort of sweep for the trio of panelists, and that's very helpful because I really do share a lot of the views of my colleagues, so I'll try to pick in a few areas to build on and some gaps to fill. I always have to say, as I'm a government employee, that I'm here speaking in my personal capacity, and that my views don't represent the official views of the U.S. government. I'd also like to start by saying that, you know, while I will share the view of my colleagues that the current international tribunals may not be an effective way to move forward here, I do want to start by saying that I am a strong supporter of the ad hoc tribunals and the tremendous work they've done towards moving us in a direction towards greater international accountability for, you know, horrific crimes. And while we have learned some lessons along the way, that have been tailored to different situations. I mean, each situation of atrocities has been unique, and so dealing with it in that context, with the local capacity, with the local population, addressing their concerns means that there is not one size that fits all, and I think that we'll see that as we move forward even in the terrorism construct. So I'll start by addressing maybe a few of the specific challenges that these types of ad hoc tribunals, or more as they've moved in the direction of being called hybrid tribunals, where they are more in the national jurisdiction, but still with an international flavor. Some specific challenges that maybe we've seen that would pose challenges as well in the terrorism construct. I mean, a few of those that come to mind is, one of the great values that Sierra Leone really built into its court model by holding it in Sierra Leone and by putting a very public component to it, which we've seen from the international tribunals because they were based largely, with the ICTY in Europe in particular, where they were able to really start getting the message out. In Sierra Leone, there's a very active campaign to try to involve the local village people and to get out radio messages and picture messages, even to villages where there were individuals that didn't, speak English per se, which a lot of these courts are conducted in, to be able to actually educate them about some of what happened. And this, what we call sort of truth-revealing process, has been a critical part of the healing process that these international tribunals have contributed to. I think that's a particular challenge in the terrorism construct for a number of reasons. One of them is because terrorism trials, by their very nature, don't lend themselves to complete transparency and openness. And it's for a number of reasons. I mean, first, they often involve highly classified information that even the way in which countries come about the information that can be used in terrorism trials is often classified and secret in its nature. National courts, national jurisdictions tend to be more reluctant to turn that over to international bodies. If you have classified information or means and methods of collecting that, you're probably not going to be as willing to share certain information in an international forum where you can't secure and be certain how it's going to actually be used in a trial process. And we've worked out agreements in the ICTY context that helped us a lot in that vein, but I think you still have a challenge when it comes to some of the terrorism trials. And in particular, moving into a closed session or having to hold certain evidence that's outside of the public airing that many of these tribunals have done may cast some concerns on legitimacy. And I think that's particularly in the backdrop of what you've heard from my colleagues about some of the legitimacy concerns that you have anyway versus which terrorist trials are going to be those ones selected for an ad hoc tribunal or an international tribunal. And it doesn't seem that every terrorism act makes it there. So when you look at the characteristics, I don't need to go into the same details my colleagues on that, but there's always a sense of politicization. Which is a concern, and I think that hurts you in the transparency part and in legitimacy. There's also some concerns about some of the specific rules of evidence that have been used in some of the ad hoc tribunals. I have a lot of experience with the Iraq High Tribunal because I spent a year in Iraq helping support the Iraqi efforts to build this, and while it was a domestic Iraqi court that had international support, the international support was frankly the United States, the UK, and a handful of others that we could hire to come in and help. And there wasn't a lot of international support to go in because there were some characteristics of the court that made internationals uncomfortable. They wanted the death penalty. They felt that for Saddam Hussein and his henchmen that they deserved death, that it was hard to imagine an Iraqi court where you could have the death penalty for a murder on the street, but you couldn't have one for somebody who mass murdered hundreds of thousands of people, tortured millions. And so that is a real big challenge because members of the international community couldn't live with the notion that a death penalty would be in a court that would get an international stamp. So it remained the Iraq High Tribunal. International judges didn't come to support it, even though the court's jurisdiction originally invited them in. The Iraqis changed that 2 years later and didn't invite international judges in anymore because none had come. I think that's a particular challenge you have is, one, dealing with this issue of the death penalty. I think you have another in dealing with the linguistic issue. Again, the Iraq High Tribunal was in Arabic, and some argued that that meant it couldn't be as legitimate as some other tribunals because Westerners couldn't see it and understand it in English. But by the same token, it was on Iraqi television. Not everybody had a television to watch it on. So, there are challenges in all of these models, but I do think in the context of that particular experience, you can take a look, and there are challenges when you look at this death penalty. And I would submit that there probably won't be an international tribunal anytime soon that authorizes the death penalty based on the direction of the international community in that regard. Another area where we saw some experiences, both in the Iraq High Tribunal but also in the ICTY, were in the ability of defendants to defend themselves pro se. So you had Milosevic and you had Saddam Hussein, and while the Iraqi judges actually did a pretty good job in controlling Saddam after the first session or two, Milosevic railed for years. In a post-conflict environment, as untasteful as it may be at times, it may not be quite as much of a concern as it is in the terrorism conflict, where many times, acts of terrorism continue to occur. There isn't a start and end. And so if one could imagine a platform for Osama bin Laden or another colleague to get up and basically, call to action fellow conspirators throughout the world, that could be a concern. Is that really the platform you want to set up your courts for? And yet at the same time, once you've taken that step, are you really going to limit what they say, how they say it? You can put constraints on it, but it's always very difficult to do. And so I think, those are just some specific challenges from some of the models that we've seen. I fall back and sort of, share the broader perspective of my colleagues that, more broadly outside of these specific issues that could prove problematic in the terrorism connection, I think that more broadly, the international community is moving away from these ad hoc tribunals, even at a time while the ICC is growing, because there is the ICC. B, they're in the wind-down strategy for these major tribunals that have been very effective in moving us towards accountability. But for all their successes, they've also highlighted a number of challenges. And one of the biggest ones that you're going to find moving forward, and it plays into all the concerns of politicization and everything else, is the money-raising part. Most of the original UN Security Council created mechanisms were set up so that there were required assessed dues that came out of your UN dues. We pay such a large percentage as the United States government that we paid very large amounts towards those tribunals. The Special Court for Sierra Leone was voluntarily assessed, which meant, they went around with a tin cup trying to collect money. And as the trial went from 3 years to now a court that is still sitting, and was not expected to go beyond 3 years initially, the willingness of donors to continue to put money in there has been very challenged. And even the Lebanon Hariri Tribunal is 51% collection, basically, and 49% paid by the Lebanese government. And so this model, while, I would argue that you can actually get better amounts of money when you're talking about, a Rwanda, a genocide of 800,000 people, or, hundreds of thousands killed, or an ethnic cleansing, or think about Srebrenica, and it all makes sense. But when you talk about one terrorist act that, may have killed 20, 50, 100, 2,000, where not all nations are of the same view as to the character of what occurred, then I think you have a challenge in trying to get these funded. And considering that the United States government has generally paid a majority of most of the tribunals, when you look at percentage cost, it becomes challenging to try to get that born throughout the international community. And while the call for accountability tends to be widespread, the ability to pay for that accountability isn't always as widespread. And then I would just move a little further into some of the points that were also raised about, the trend is away from these tribunals for some of these reasons towards this national court model. I mean, it is built on complementarity. It is built on the principle that national courts should take measures of accountability when they can. But terrorism cases may be quite well suited, in fact, for national courts. I mean, if you take a look at, a terrorist attack, whether it be the Spain, train bombing, or the Japanese metro bombing, subway, UK terrorist attacks, I mean, you look at many countries, and their desire will be to take action within their own jurisdiction. And there is a tremendous ability of many countries that are victims of such attacks to take actual action in their national courts, which are very well developed to handle these. You compare that a bit with a post-conflict situation, which is where a lot of the ad hoc tribunals have come, and the domestic court systems are often not capable of handling it. And so you end up with a different dynamic here, where in a lot of cases you will actually have domestic courts that are capable of handling it. Whether they are willing to handle the act is another matter that still always needs to be addressed. But along those lines, I mean, in a post-9/11 world, the international cooperation and the capacity of domestic and national courts to take action has greatly expanded. I mean, at the moment of 9/11, a lot of countries didn't have the same robust counterterror framework that they have now. And right now, a lot of countries have, both at their domestic level and through cooperative arrangements, terrific cooperation on sharing of information, on trying to block terrorist finance and assets, on watch lists, no-fly zones. I mean, methods other than pure justice of addressing this holistically. And so, through strengthened national courts and jurisdiction, you may actually be able to more easily extradite somebody, handle some of these issues of evidence more locally to where it's collected. You'll have an ability in your own domestic laws to deal with classification issues probably better than you can in an international forum, where the rules may or may not mirror your own rules on classification. So, I obviously share somewhat the view that, as we move forward, we really do need to look at national frameworks, and that when those fail, there is obviously continued need to move towards this definition of, what is terrorism and to address that as we move forward. But right now, at the phase we're at, the focus seems to be away from certainly the ad hocs towards domestic or national, and then looking to the future. But the future really hinges upon a definition that's not politicized, that can be agreed upon, and that's a tremendous challenge.
My turn.
Yes.
So what shall I say? I think to prosecute the crime of terrorism, 3 basic conditions must be satisfied. First of all, the crime must be adequately defined with sufficient clarity to comply with the legal certainty prong of international law or of criminal law in general. Secondly, the crime must be included in the subject matter jurisdiction of the International Tribunal. And thirdly, the crime must not fall within the confines of circumstances that have come to be recognized as a justification. And perhaps these matters have been touched upon by our 3 speakers from different angles. Let me just say a brief word about each one of those. First, as far as the definition of terrorism is concerned, I have no doubt in my own mind exactly what terrorism means. I think it is clearly defined, also clearly defined in my own mind. But the controversies in this regard that exist in international politics today is based on this third prong, and that is namely whether there would be certain justifications for acts of terrorism to be committed. And there is a strong body of opinion, including particularly amongst Arab groups, Muslim groups, that the end justifies the means, that there are circumstances in which the use of terror violence would be, if not legal, then at least legitimate. And you might be surprised to know that there are actually a whole range of resolutions of the General Assembly of the United Nations during the 1980s which supports this view, or can be read to support this view. Those resolutions mainly concerned my own home country, South Africa, which was subject to terrorism at the time, and where the terrorists were arrested and prosecuted, in some cases sentenced to death, because we still had the death penalty at that time. And the United Nations General Assembly say, no, these guys are not terrorists, they are freedom fighters. And again, in my kind of radical view, I believe terrorism is terrorism is terrorism. There was a judgment in the Celebishi case which said that terrorism is not an armed conflict, absent the protractive element of an armed conflict. But that must not be taken to mean that terrorism cannot be used as a strategy of war in armed conflict. And as a matter of fact, has become quite frequent amongst belligerents to resort to acts of terrorism as a means of armed conflict, of conducting hostilities. And those should be punished. And just commenting on what Laura said, yes, terrorism should be prosecuted in national tribunals, but that becomes more complicated if terrorism is used as a mechanism of combat in armed conflict. Then it is more difficult to prosecute terrorism in national courts. And that is where the international tribunals come in, that have been created, as has been mentioned several times here, as a stopgap. The first right and obligation to prosecute these international crimes remain with national tribunals. It's only if the national tribunal is unwilling or unable that in the case of the ICC can step in and then prosecute. And what we've learned so far from the limited history of the International Criminal Court is that it has been confronted with very difficult problems, part of which is determined by the fact, compared to the ad hoc tribunals and the hybrid tribunals, that the ICC is not a post-conflict tribunal. It operates while tensions and hostilities are still prevailing. And that makes implementation, state cooperation, extremely complicated. I'm always reminded of a remark made by the delegation of France at the Rome Conference for the International Criminal Court, who said that the success of the ICC will be measured if it turns out that there are no cases to prosecute. That means that national courts will be prompted to comply with their international obligation to bring perpetrators of these serious crimes to justice. Now, of course, that might still take a long while before we reach in international relations that stage where the idea has filtered through that certain atrocities simply cannot be committed with immunity, and that they might almost disappear from the face of the earth, but we are so far removed from that. So that the French idealistic statement is still far from being put into effect. Terrorism has been excluded from the subject matter jurisdiction of the ICC, quite ironically, initially upon the proposal of the United States way back in 1995, with the first session of the Ad Hoc Committee. The United States' first critique of the ICC was to exclude international drug trafficking and terrorism from the subject matter jurisdiction of the court. And the argument was used at the time that the United States has developed, for example, the combat against international drug trafficking to almost perfection, and used methods that are highly classified, and is not prepared to share that information with the rest of the world, and therefore keep it out of international tribunals. I might just say that because of this concern of the United States, special precautions have been built into the rules of procedure and evidence of the ICC to maintain confidentiality of classified information. So that concern about classified information becoming public has been addressed in the ICC, especially through its rules of procedure and evidence. What is interesting is that in the end, the main reason why terrorism was not included after we had proposals by Spain and a few other countries with definitions of terrorism was because we ran out of time and there was no chance of reaching consensus on a feasible definition of terrorism for the reasons that our three speakers have indicated to you. But a decision was taken at the Rome Conference that terrorism could be considered, its inclusion in the subject matter jurisdiction of the ICC can be considered at the review conference, which, as you might know, will take place on the 31st of May to the 10th of June this year in Kampala in Uganda. The Netherlands put forward a proposal in the Assembly of States Parties to include terrorism in the subject matter jurisdiction of the ICC, but it has been decided by the Assembly of States Parties that this will not be considered at the Kampala conference. They want to concentrate on the crime of aggression, and so that the proposal of the Netherlands, there were also two other proposals, the one to include international drug trafficking, and the third to include in the prohibited weapons of mass destruction. The Assembly of States Parties have referred those matters to a special committee to be considered and to be considered after the review conference, the Kampala review conference, so it won't come up before the review conference. I also just want to mention that although terrorism is excluded from the subject matter jurisdiction of the ICC, what actually are acts of terrorism can be prosecuted under the rubric of other crimes, not as terrorism, but, for example, launching an attack against civilians or civilian objects, which has an element of terrorism. What is also interesting in the international sphere is that although terrorism is included in the subject matter jurisdiction of the ICTR, there's been no prosecutions in the ICTR. Although terrorism is not included in the subject matter jurisdiction of the ICTY, there have now been several cases in the ICTY prosecuting acts of terrorism under the name of terrorism. And this is based primarily on a provision in Protocol 1 and Protocol 2 that prohibits acts or threats of violence, the primary purpose of which is to spread terror among the civilian population. The first number of cases in the ICTY that used this as the basis for prosecution did not call it terrorism. But then in 2006, in the Garlich case, the court called it by its name and said this is acts of terrorism. And so they prosecuted this crime defined in Protocol 1 and Protocol 2 as an act of terrorism. I might just say also that this definition in Protocol 1 and 2 does not completely comply with the definition of terrorism, because terrorism is a special intent crime, or to be more correct, a double special intent crime. You commit the act to spread terror amongst the civilian population. But furthermore, so far they go in the protocols, but there's a further special intent. You do that with the purpose of achieving a certain ideological, political, or religious objective. And that is not part, this latter part of the definition of terrorism is not part of the adjudication in the ICTY and also in the Special Court for Sierra Leone. So although those convictions might be acts of terrorism, they could also fall short of terrorism by not having this second purposive objective of the act of terrorism. So the inclusion within the subject matter jurisdiction of the ICTY, of the ICC of terrorism will not be considered in Kampala. That is something for the more distant future. But as I said earlier, there are crimes within the jurisdiction of the ICC that can be prosecuted as terrorism. We have heard much this afternoon about the difficulties confronting these international tribunals in bringing perpetrators to justice. We have mentioned lack of state cooperation. I also just want to, perhaps in conclusion, because I don't want to take up too much time, just also refer to a very interesting development in regard to the principle of complementarity. To my students, spelled not with an E and not with an I, right? The principle of complementarity was a basic principle of the ICC even before it was born. And it was fleshed out in the ICC statute upon insistence of the United States, Articles 15, 16, and 17. And the emphasis has always been on the ICC, the circumstances under which the ICC can exercise jurisdiction, the so-called admissibility problem. At the Kampala conference in June this year, the main focus will be on the definition of the crime of aggression, to put that into the subject matter jurisdiction. But also, 50% of the conference is going to be spent on stock taking under 4 different headings. That is to see where the problems that have been disclosed over the last 9 years and where we go from here. And one of those 4 points is the principle of complementarity, and the so-called focal points to deal with this is the delegation of South Africa and Denmark. And they put an interesting twist to this, which is relevant to our discussions today, which they called positive complementarity, where the emphasis now shifts upon the circumstances under which the ICC can exercise jurisdiction to, let's get the states to prosecute these crimes so that they will not be prosecuted in the ICC. And part of that is to encourage states to bring their national legal systems in conformity with the definitions of crimes in the ICC so that they can prosecute these crimes, so that the crimes need not go to the ICC. So the emphasis after the Kampala conference, also from the ICC perspective, is going to be on encouraging states more and more to bring these perpetrators of crimes, and I would imagine including the crime of terrorism, to justice, so that the need of prosecutions in an international tribunal, with all the disadvantages, state cooperation, and can I also just mention a particular problem in Africa, is the tension between retributive justice, that is prosecuting, and restorative justice, that is making peace. In Uganda, for example, they could not arrest any of the members of the Lord's Liberation Army. They have come to the government of Uganda and say, we will negotiate peace on condition that these summonses against us be withdrawn. Of course, that's no longer in the hands of the government of Uganda, but they really want to do this because for them, peace in the country is a greater priority than the prosecutions. And so this tension is something that will also have to be considered in Kampala, and how we can deal with the complementarity issue so as to avoid this kind of tension and problems that exist in different countries. As I said earlier, part of the problem is that the ICC starts prosecutions while the conflict is still pending, still going on, where the ad hoc tribunals are post-conflict tribunals and operate more easily in that respect than it does when you have to prosecute people like Mr. Coney, the leader of the Lord's Liberation Army, at a time when the Lord's Liberation Army is still fighting a war. Thank you.
Before I open it to the floor, I'm wondering if you would all would like to take a few minutes just to respond.
Yeah. I have an additional comment, maybe just adding on to what everyone else has said, and that's coming back a bit to the definition, this idea of terrorism. And as you mentioned, that the ICTY, in a sense, has dealt with terrorism. Well, that's because the law of armed conflict already does prohibit certain acts. I mean, I would consider that the ICC, in fact, already addresses terrorism because it goes after people that have committed war crimes, crimes against humanity, and genocide. And to me, those are forms of terrorism. So certain crimes are already being addressed. They just have a different technical terminology. Also, the law of armed conflict does prohibit, and this is what you were exactly referring to, specific acts that are meant to terrorize the civilian population. And those are the express use of that term, terrorize. But, it also, what I would consider to be terrorist attacks, the law of armed conflict also prohibits attacks on civilians and civilian objects, indiscriminate attacks, attacks on places of worship, attacks on works and installations containing dangerous forces, and the taking of hostages, and murder of persons that are no longer participating in hostilities. So it's not to say that there aren't already crimes out there. It's just a matter of, what does this term terrorism mean? Is it really a crime? Is it really just a method of being employed? And how do branches of law, international law, I guess is what we're speaking of right now, how is it already criminalized? And such, if we do anything in addition, how are we going to make it sure that it's complementary to, with an E, and not, working against some of the other aims of the branches of law that are out there. And maybe just on when I had mentioned earlier of my concern, and at least the debate that's still going on with the Comprehensive Convention Against Terrorism, if it somehow made acts that are normally legal in warfare, at least at the international level, such that if I'm a rebel group and I'm fighting against a state, under the law of armed conflict, I'm allowed to attack a military target. But keep in mind, anything I do as a rebel group, it's always criminalized domestically. So this is the distinction between what's allowed under domestic law versus what's, in a sense, permitted in international law. Clearly, even in international law and domestic law, I can't commit a war crime. I can't attack a civilian object. But at least internationally, I can still conduct as an equal belligerent to the state. And you were mentioning the concern and the tension of retributive and restorative justice. Well, even in the law of armed conflict, states recognized when they started making new rules that would relate to non-state actors, so these non-international armed conflicts, since there's no combatant immunity, such that anything I do as a rebel is illegal domestically. I mean, I can't imagine a state that would permit me in its legislation to take up arms against it. The treaty itself, and a second additional protocol, it provides that there should be amnesty granted to the extent possible for the fact of taking up arms. Because they realize, since even if it's permitted action and I was a good rebel and I did everything that was consistent with the law of armed conflict at the international level, why should I stop fighting if I know at the domestic level I could still be tried for just taking up arms, even though I only attacked military targets? Well, that's why that provision is in that treaty, that hopefully at the end of hostilities, at least for the mere fact of taking up arms, I won't be tried or held in prison. But it's not supposed to cover the severe crimes, the violations of international law, like war crimes. And yes, there is this tension and this issue of whether, what crimes should be amnestied, what crime, can be off the table if you want to make peace. And it's part of this whole tension then, too, in defining terrorism.
Well, I think you've identified the two problems that are insurmountable. And one is first of all of the elements of terrorism are criminalized somewhere. Treaties against hijacking, kidnapping, all the individual particularized crimes are crimes. It's just glomming them together and brushing them with the label terrorism. That's the political part. And you're right. The perspective of the person who applies the label is pivotal. And then the second prong, you're also right, and that is we've never resolved the tension between whether terrorism falls in the camp of crime or war. If you go back,
Yeah, but I think it's, sorry.
if you go back to the 1960s regime in South Africa, they clearly considered Nelson Mandela a terrorist, right?
Not really.
Go with the argument. It's a safe argument.
The British considered George Washington a terrorist. It depends on the perspective of whether it's a war or a crime, and who the perspective is applying the.
Well, but see, then I would argue that's why the terrorism definition has to be very clear how it relates to the law of armed conflict. Because yes, if I even use, when I describe myself as that non-state actor, I said rebel, which could have a negative content too. Of course, to the state, I'm most likely going to be labeled a terrorist, even if I do everything consistent with international law. That's why you have to look at what does the international law rules say versus domestic criminalization. And we have to make sure that at least at the international law level, because at least also being a former ICRC person, I want as many states and non-state actors to respect the law of war as possible. Already it's tough to get non-state actors to respect it because, as I said, domestically everything they do anyway is illegal and they'll be punished. So we don't want to have one body of international law, the law of armed conflict, that says certain acts are allowed and you're not violating international law if you behave this way, and then another body of law like this comprehensive treaty that the UN is now negotiating on terrorism, that might start to say to non-state actors, well, now you can't attack, it's an act of international terrorism under this treaty if you attack with explosives a military base or something like that, which would normally be legal under IHL. So then you have contradictory norms, and that starts to undermine both bodies of law. So it doesn't, while I agree that it is the problem that the term is used pejoratively, and that's why it's going to be very hard to come up with definitions. And maybe we never will, and then that's fine, because we do have a lot of things that are prohibited already. We just need to get those enforced. But if we only speak about the law, then we can avoid the names, unless they start to overlap.
I just have to come in on the Nelson Mandela thing.
I just threw it out.
Yeah, no, I've heard this said before, even by my former colleague John Dugard, who's now the special rapporteur on this in Palestine, saying, well, what is terrorism? We also said Nelson Mandela was a terrorist. That argument is quite often used by people who want to say there's no clear definition of terrorism, which, as I said, I reject. Nelson Mandela was charged with high treason, not with targeting civilians or civilian objects. So, with a very great respect that I have for Nelson Mandela, I also don't want his name to be associated, even in this paraphrase, with the suggestion that he might have been guilty of acts of terrorism because he was not.
Well, and that dovetails with Scalia's dissent in Hamdi, was it? That we should just go ahead and try him for treason.
Yeah.
Why don't we try our own for treason? Hamdi was a U.S. citizen. The treason crime is laid out in the Constitution. It's the only crime defined in the Constitution with the evidentiary standard put in the Constitution. So why isn't that the road we go down?
Well, and this is where maybe I'll sort of jump in. I mean, in hearing the discussion, in times of war, I don't think you necessarily have an either or. I mean, just like we have state court and federal jurisdiction, there is often overlapping jurisdiction. And so if you start from the principle that a certain act attacking, targeting of a civilian in a time of armed conflict may well be covered as some sort of a war crime, depending upon the circumstances, then there may be an effective mechanism for doing that, such as a war crimes tribunal of some sort, a military commission of some sort, while the same crime in a slightly different context may be prosecuted as an Article III court violation, as a crime against an American citizen. So
Or
it could be
treason.
prosecuted in our federal courts. And in fact, you're seeing right now that play itself out as certain courts, certain cases have more of a conflict nexus and are being designated for military commission, whereas other cases may have more of a traditional terrorism nexus and therefore may be designated for Article III court or some other way. And it isn't neat in the sense that it's hard to say where one stops and the other begins. But you may have overlapping jurisdiction. And I think, if the goal here is moving forward, rather than worry about the binning exercise, the categorization exercise, which I think is what a lot of the focus has been on, trying to fill the gaps is where we really want to make sure that in the areas where there's no method that seems to be occurring, how do we pick that up? And I think that's where some of the definitional parts will play in. There's one other thing I just wanted to mention, since it didn't come up in any of our discussions, and I think in the context of terrorism, we should probably at least mention it, which is the security aspect of terror trials. And again, I'd be the first to say that a war crimes tribunal can be very difficult in managing security aspects as well. But when you do discuss this more post-conflict environment, and particularly the original ad hoc tribunals, which removed them from the zone of conflict, you have a much more stable place to run a court. We certainly didn't experience that entirely in the context of the Iraq High Tribunal, because while the conflict phase may have subsided in Iraq, there was nonetheless still a large amount of internal unrest. And so there were additional security measures that were taken in trying to manage a domestic court in a post-conflict Iraq at that time, with all of the security situations that were. And I think you're going to see something like that when you look at terrorism trials in general, if they really can be prosecuted, even domestically. I mean, this is a challenge for national courts as well as international fora, is, trying to secure a terror trial can actually be very difficult. We've done it successfully in the United States in many occasions, but depending upon the politicization of, especially when we talk about Islamic terrorism, the politicization that you have from running some of these courts, it is a pretty difficult thing, at least when you look at the U.S. system, to get a secure jury and try to handle those issues of, an ongoing active, whether it be an enemy or whether it be just a force of terrorists that may want to undermine the legitimacy of the trial by taking certain types of acts against individuals who participate. And it's a little less common in a post-conflict environment removed from the area where people are working towards reconciliation to actually have active attacks on the court itself.
Well,
but it's nonetheless a challenge.
The mayor of New York City has
Right.
decided that he cannot secure New York City for the Khalid Sheikh Mohammed trial.
And this morning
Yeah,
they
but-
reinstated apartheid in South Africa. Did you hear the news? After Eugene Terblanche was murdered over the weekend, he's a white supremacist fanatic. And this morning when the two youngsters who killed him appeared before the court, the police separated the white and the black community because they were going to kill each other. And so, it's a very, can I just come back to the debate just reminded me also of something at the Rome Conference when the question emerged, why do you want the crime of forced pregnancy if already rape is a crime? And the simple answer to that is forced pregnancy adds a dimension to the crime which is deserving of a higher sentence. It's an aggravating circumstance. And the same, although we have many crimes that include elements of terrorism, if you also have terrorism as terrorism, that adds a dimension which will warrant a higher sentence. And so that's why we think that terrorism should go into the ICC statute.
Sandy raised an observation that I'd like to turn into a question for our ICC expert. And that's the question of the winding down of the ad hoc tribunals. Sharif Bassiouni noted recently and agreed with you that, as these ad hoc tribunals wind down out of business, we're going to be moving into a period of dormancy in international criminal law that's similar to the post-Nuremberg Tokyo Tribunal period. And the ICC will be the only vehicle to carry the agenda forward with respect to international criminal law. And so the obvious question is it up to the task, or will it rise to the task of being the vehicle to carry international criminal law forward?
Let me say that at the Rome Conference, they coined a phrase, and that is that the Security Council is suffering from tribunal fatigue, which means that the Security Council, it becomes such an expensive operation that Security Council-created tribunals is something of the past, except for the one in Lebanon. And that, by the way, could not be prosecuted in the ICC for different reasons, but also because it doesn't reach the threshold of subject matter jurisdiction. So that's why they resorted to the hybrid tribunals, which is a local tribunal with international components worked into it. But the idea of creating tribunals by the Security Council is something that is not going to happen soon again. And so there is this vacuum. And this is what Sherif Bassiouni has been emphasized all along, is that even though we are now experiencing the teething problems of the ICC, the difficulties in state cooperation, I forgot the number, but at the conference we had in the United Nations 2 weeks ago, they indicated that about a third of the member states haven't paid their dues to the ICC. And so they are operating under all kinds of constraints. But Sherif Bassiouni is quite right that we are putting something in place that is, in a sense, permanent, and that does fill a gap. And in spite of all the shortcomings that are now coming, is now surfacing, I think in the long run, it will be a worthwhile exercise in just putting a tribunal in place that can prosecute these crimes if national criminal justice systems are unwilling or unable to do the same. So I think in the long run it will succeed, but it's going to take some time, and that's part of the agenda of the review conference in Kampala, is to look at the problems of the last 9 years and say, how are we going to move forward with complementarity, with the impact of crimes on victims and communities, state cooperation, etc. Those are themes that are going to be discussed, and with the pledges of states, we hope will be resolved in part.
Open the questions to the floor. We are recording, so if you would like to ask a question, I ask that you please use the microphone. Otherwise, the question will just be a shot of your lovely face, but no sound. So I'll start one microphone off just over here at this table, and one over here at this table. And though I usually abdicate fielding questions to the person speaking to do as little work as possible, since we have 4 panelists, I'll do my duty. And so, would anyone like to start us off? Yeah.
I have a question for Professor Kelly, specifically about how it would be an us versus them scenario with the Islamic world. Now, it's often said by people that they're Muslims, and then there are people like Osama bin Laden who are Muslims, and it's generally thought that they don't really follow the dictates, and that they aren't supported by the vast majority of the Islamic world. So if the crime of terrorism is simply challenging these, what many Muslims believe to be false Muslims, then what's the harm in facing them?
The harm is the potential use as a propaganda tool by the, how did you describe them, the uber Muslims?
Oh, no.
Okay. So, yeah. I mean, you're quite right. Not the entirety of the Muslim world certainly supports Muslim terrorism, but the fundamentalists, the jihadists, this is an easy and handy propaganda tool for them to perpetuate their own kind. if you start going at them through internationalized tribunals that they don't participate in, and they're not part of the institutional process, you have to take a look at it from the perspective, of the Arab on the street in Cairo, right? You have an array of Western judges wearing black robes trying a Muslim in the dock. How does that play on Al Jazeera? You see what I'm saying? And that perception tool is easy to hijack and turn to their own purposes. So why do it? I mean, why not work a little bit harder to incorporate, moderate elements from Islamic states into the process? Why not go down that road a little bit further?
And I've given this up, I want it back. So how are you going to do that? I mean, what elements would you say could be brought in from the Islamic world that would achieve the purpose of making it legitimate to the Muslim?
Right, and that's what this is all about, right? Legitimacy. You need to begin where they have begun with the rule of law Islamic states like Turkey and Pakistan, where you have well-educated judicial class and lawyer class that apply. There's 5 different schools of Islamic law, and they apply the Cairo-based, more moderate influenced version of that. You're never going to get the Sharia states involved, but you can, by getting the more moderate countries involved, get the camel's nose in under the tent, to use a pejorative that they use. And by that, you ameliorate how this looks to the guy watching Al Jazeera, right? If you've got an Islamic judge up there on the bench, an Islamic prosecutor helping out, assisting in the prosecution of the Islamic terrorist, if it becomes Muslims participating in the process, instead of just Christians, Jews, Hindus, and atheists prosecuting Muslims, and they still view the world in parts of the Muslim world in those terms, then you're going to begin to mitigate the use of that as a propaganda tool. Do you see where I'm coming from? Yeah.
Well, we're seeing it as just small steps at a time.
Yeah.
You get one, you get another one, but you're saying Pakistan and...
There's a precept in Islam, and I'm not Islamic, so I'm talking about this as an Episcopal. I'm a member of the Frozen Chosen. This idea of Maslan, the public good. Yeah, it's let me get the proper pronunciation here. The public good can override individual concerns. It's one of the precepts in Islam that you're supposed to do good for the entirety of the public. Maslah, M-A-S-L-A-H, the public interest. That's the component of Islamic law that can be creatively invoked to get around quite a bit of Sharia. And it provides a little bit of flexibility and fluidity into what is an otherwise very rigid process, because it becomes an excuse for you departing from the more rigid aspects of Islamic law. Modern juridical theorists in Islam, are starting to talk about that as a way to bring some Islamic states more into the modern world and engage more in international law.
Can I just add to that? There's a resolution of the General Assembly of 1972, I think it's Resolution 3034, which I always thought was a very important resolution because it called upon states that were subject to acts of terrorism to try to understand what it is that drive the terrorists to these desperate acts. Because you must remember that the terrorists place their life at stake, and so that the obsession that drives them to do what we can easily condemn as an irresponsible act must be something gross. And governments, by just punishing without trying to come to grips and see if something can be done about that which drives the terrorists to these horrible acts, is something that the General Assembly encouraged, and so do I, because I'm also one of those people that believe that terrorism cannot be conquered through prosecutions or through armed conflict. Because for every terrorist that you kill or imprison, you create 1,000 others. And so that the problem of terrorism, the final solution of terrorism, must be found at, call it perhaps the diplomatic level, consultation, deliberation, but mainly coming to grips and understand what it is that drives these people to these desperate acts. And I think that's an important resolution that should be taken more seriously. I don't mean to say terrorists should not be prosecuted, because as I said, terrorism is terrorism is terrorism. I find no justification for it, and they should be prosecuted and punished if you can get hold of them. But in the end, in the long run, you're not going to solve the problem of terrorism through prosecutions or armed conflict.
Mr. Green.
I have a question about the interrelationship of state laws that criminalize various acts and international law. I've heard something about the relationship going on here. I'm not a specialist in this area at all, but an avid news junkie, and I noticed last week when they arrested the Hutari Christian militia in Michigan, there was this line of commentary that was questioning, well, why don't we prosecute these groups as terrorists? And I guess one could say the same thing about abortion clinic bombers or any other kind of group that uses those methods. But I wonder what difference does it make a difference for international law, perhaps in terms of weakening, a sense of opposition to terrorism or a climate against terrorism if national governments prosecute these groups against something else? Should they be inspired, encouraged to append the label terrorism to those acts? And then just as a related question, I guess, are there any national jurisdictions that have particularly good laws against terrorism, either internationally or domestically, that could serve as a good model for law in this area, for the international law?
I mean, I'll start, and then we'll pass the floor a little bit, just on a couple thoughts on that. I mean, I think that there can be a merit to attaching the label terrorist. I mean, I think that there has been before. There tends to be a desire to do that because there is a sense that the sentence will be higher for a terrorist crime than a crime of, whatever it happens to be, protest, speech, whatever, because obviously once they carry the act and the intent and would meet all the elements, I just think there's a sense that there is a greater condemnation for that type of conduct. And so if you want to delegitimize either, the individual who is carrying out that act, and if you can fit it in that rubric, then there will often be a desire to do that. But I think, from what you've heard from the panel, notwithstanding that fact, it may not be necessary in many cases. And, a lot of prosecutors will just move easily towards whatever crime they can prosecute. And so, the goal of most prosecutors is to actually win. And while terrorist cases are often won, by the same token, if there is a lesser way or another way to charge something, they may well do that. So, I mean, I'd mention that as one point. As another point, clearly I would say that in an instance like that, the domestic courts are by far the preferred method for taking action. Then, if there is a capacity, and obviously we have capacity to take, terrorism cases to trial in the United States, we have a long history of doing it. Clearly in those instances, there's no merit or value in looking broader for any international support or help when that's required. That doesn't mean that national prosecutions don't build to a growing sense of, nation states that are able to take that kind of action, and therefore it contributes to the furthering of prohibition on terrorist conduct. But nonetheless, it's a little different than a high-profile terrorist international case. So I think that, there's still a strong effort towards this national focus. For a couple examples I'd give, the British government has taken a lot of steps in the last several years to strengthen its counterterrorism laws. Interestingly, the French have always had surprisingly robust terrorism laws based on some of their own history. Even Spain has taken a lot of steps. I mean, our European allies, and we have a terrific constitution in the United States. But it also brings with it a lot of rules that are not necessarily international rules with respect to prosecution and trials. Everything from hearsay to some of our self-incrimination and other rules that are, unique to the United States, but also can pose a problem in terrorism cases or other types of cases. And so while these protections are extremely robust and important for our country and our founding, nonetheless, other countries we have to recognize don't have exactly all the same principles and protections that we have. And so that may advantage them in prosecutions at times where I would say we still have successful prosecutions for terrorism. We have a lot of them. But nonetheless, there are other countries that can go even further and have an ability to hold people beyond whether it's 48 hours or, these types of basic procedures that we have. So.
Well, I'm going to utter the phrase that will take us into a 3-hour discussion.
Oh, no.
Guantanamo Bay. Well, that hasn't been uttered yet today. You have to look at what the government wants to do. If the government seizes you, does it want the intelligence that you have, or does it want to prosecute you? If it wants the intelligence that you have, it sends you away to a legal black hole where you can be aggressively questioned. A place like Bagram Air Force Base, Guantanamo Bay, the Navy brig, if you're a U.S. citizen in South Carolina, like Padilla or Hamdi. If it's not particularly interested in the intelligence that you have, if it wants to go ahead and prosecute you, then it sends you to court, like John Walker Lynn. Or Zacharias Moussaoui. And so you have to figure out what the government wants. Does it want to know what you know, or does it not care what you know and you can go ahead and be prosecuted? So prosecution versus interrogation depends upon which track you're going to go down very much, I think. And obviously if you're aggressively interrogating someone to the point of torturing them, that tends to taint a lot of the evidence that you would use in court. And that evidence becomes inadmissible for a prosecution. So you put yourself in a catch-22 as the government. You're almost never going to successfully prosecute interrogees because you've ruined the evidence. So you kind of have to make that decision up front early on as to which way you're going to go. If you don't, then you're stuck, kind of like where we are now.
Well, yeah. Let me put one comment and then I'll turn it over. But this is an area where you may have, again, this idea of overlapping jurisdiction. When you talk about an act that may well be an act of war in one context and you apply it in an international humanitarian law of armed conflict framework, you may have authorities that aren't normal domestic authorities that apply within your territory to your citizens at all times. And so when there may be, I think that there may be a relevance to this idea that obviously the government will choose among fora what makes the most sense in certain circumstances. But that doesn't necessarily mean that either one or the other is illegitimate. And certainly if you look at the current context, there is an approach by our administration that uses both the detention of enemies who are encountered on the battlefield, but that also uses prosecutions where appropriate under the circumstances. And so, a government is not necessarily constrained to one size fits all when there are overlapping jurisdictions. It may be controversial at times, but nonetheless, that is, as a government which is responsible for the national security of its own citizens, there will be choices that are made at different times that do advantage the government. And I think that that's generally what people will ask their government to do, is at least to take those steps that are within the legal authority and powers. And obviously, if you operate outside of those, then by every means, that should be called into question and account.
And I was going to go along the lines of what Sandy said, or at least bring up the issues. I don't think he'll go along the exact same lines in conclusions. But when you raised the question, you mentioned a domestic incident, the militia, right? But really your question raised, as Sandy then pointed out, and Michael, that, okay, now we use the term terrorism, and in the discussion a lot we hear today, like Abdul Muttalib at the attempted Christmas Day bombing, is where does terrorism overlap, again, with the law of war framework? And again, if we're in domestic U.S. law, like many countries, has defined terrorism. This is part of the discussion of why they may want one at a comprehensive definition at the international level to deal with all these different definitions domestically. It wouldn't change that per se, but there certainly are crimes labeled terrorism in our criminal statute, and that's what Sandy was referring to. Someone could be tried under that. But then we have to be very clear, what does it really mean to fall into the law of war framework? And that's where a lot of the controversy, that just because you suddenly label someone a terrorist, that doesn't mean legally they fall into the law of war framework per se. We have to look at the details of that. And then there may be other fora, but I guess this is then a little bit one of my pet peeves is, you know, we talk about national jurisdiction, and what's been a lot in the press in the U.S. a lot when we talk about where people should be tried is the idea that our national courts aren't able to handle terrorists, or by saying that war criminal makes it is stronger. Well, as we discussed earlier, a war criminal can also be called a terrorist if we don't have a specific definition. So what's the difference here? And it's disturbing to me to think that while in some instances maybe a different fora is more capable, if it's like in a battlefield, you know, the evidence is right there, maybe then, for example, a military commission would be best suited. But the idea that we've heard a lot in our press that our civilian courts can't handle, let's say, trying war crimes, I think is inappropriate. And it kind of goes against what the panel's been saying the whole time, is that we need to rely on domestic institutions. So this isn't just U.S., this is around the world, in order to end impunity for these crimes. And that's exactly what the law of war treaties actually say. States have the obligation to prosecute or extradite. How most states would do that, if they have the implementing legislation in place to do it, is going to be through traditional domestic courts. And in the U.S., our criminal code has included the War Crimes Act, which provides jurisdiction, under certain circumstances, for our domestic courts. It's not complete universal jurisdiction, that's why I said under certain circumstances, to prosecute war crimes. And Congress, when it first created the military commissions in 2006, so now we have a new version in 2009, but in the 2006 Military Commissions Act, it amended the War Crimes Act. And we can, I'm sure, have lots of discussions about the amendments they made, but they certainly didn't say, oh, it's because we need to amend it because the traditional Article III courts aren't capable of handling war crimes. No, they actually spelled out some of the provisions in more detail, making it easier for courts to use. That said, of course, I have to admit that there's no one been ever charged under the war crimes statute, although under a different statute, Chucky Taylor, for crimes committed in Liberia, was found guilty. So there are, you know, it's still the challenge of dealing with crimes that happened outside of the U.S. and even political will, but I think we have to be very careful, you know, labeling someone a terrorist, suddenly should we dump them into Guantanamo or put them in a military system? Maybe that would be okay according to the law of war, but I think we have to look carefully at it and not just at the labels. Again, as we said, that terrorist can suddenly be pejorative and not a legal term.
Just to quickly clarify something Laura said, the aut deutere aut judicare obligation attaches to war crimes, not terrorism. That's
right.
That's
yeah.
what you were saying.
Sorry,
you said it, so it.
Oh, yeah, war crimes.
Yeah,
sorry.
yeah.
Grave breaches, actually, to be more specific, of the Geneva Conventions. Yeah.
Probably got time for one more question. We have one.
Well, I have a question.
Yes, absolutely.
And this is, if it's an open forum now, this goes to something that Luis Moreno Ocampo said about 4 years ago, and I'm sure you remember this, that even though the Rome Statute doesn't call for it, he would entertain a potential investigation into corporate criminal liability for war crimes, crimes against humanity, and genocide. So, for instance, you know, the Chinese corporation that manufactured the machetes that were used in Rwanda. He didn't say anything about what standard of proof there would be, what evidence should be used, you know, if it's a knowingly standard, who they would go against, whether or not they would go against assets. The Rome Statute itself doesn't provide for this, you know, juridical persons. And there hasn't been much about that since then. What do you think about that?
Now, there's a very interesting story about this. The French delegation was very, very strong on rendering corporate bodies, juristic persons, liable under the ICC statute. And they debated this morning, noon, and night, but couldn't gear sufficient consensus on the conditions under which you will hold a juristic person liable for a criminal offense. And I personally didn't like the French proposal because it sounded very much like South Africa's apartheid laws. So it was decided that the matter will be considered by the review conference. It's not on the agenda of the review conference, and France never ever mentioned it again. So where everybody expected that the French would refine their definition of the conditions of liability and present it to the review conference, because there's a decision of the Rome conference that this matter be left over to the review conference. I asked them when I was in New York 2 weeks ago, and they said the French never ever raised it again. So just an interesting.
Is that because of Sarkozy's corporate contacts?
Could just be because they've got some other delegation now representing the French, but it's just fallen through the cracks.
Interesting,
Yeah,
interesting.
And then we could go to small arms after the
Yeah,
machetes? Is that
yeah,
the,
yeah,
that might
yeah.
get some people's interest in the U.S.?
Yeah.
Okay.
So Ocampo cannot prosecute them because it was deliberately decided not.
Yeah.
They cannot.
Yeah.
All right, well, please join me in thanking our panelists. Does close out our symposium. I would just like to extend special thanks to our partners at the Center for International and Comparative Law, particularly Professor Anaim, to Dave Day, our symposium editor, who's done a lot of the logistics and helped put all of these events together, and particularly to Lori Blank, who has been an invaluable asset in helping us find speakers, communicate with speakers, and sort of hash these issues out. So thank you all very much, and I hope everyone has enjoyed the experience.
Thank you.
These things when they're published and when they're
Oh, the comments of the speakers, both those today and those at past events, will be published in Volume 24, Issue 2 of the Emory International Law Review, which will come out probably roughly a year from now. And then the video of Professor Giora's lecture and the video of today's panel will be available soon on the Emory International Law Review website, which is a part of the Emory Law website at law.emory.edu, but is found much more easily by Googling it. So, thank you very much.
Yeah, thank you.
Thank you for moderating
Yeah, no,
very
that was
much.
wonderful. Yeah.
Thank you.
Yeah.